All right, everyone, we're going to go ahead and reconvene. My name is Adam Bateman. I'm the editor-in-chief of the Law Review here at South Texas, and I have the pleasure of introducing our next pair of speakers. First, Sara White is an applied linguist with interests in corpus design, applied corpus linguistics, and language planning. Sara is a recent graduate from the Linguistics MA program at Brigham Young University, also known as BYU, where she was a 3-time Foreign Language Area Studies Fellow, and where she also received her BA in Communications. As a researcher, Sara is also interested in the application of corpora to fields outside of linguistics and working with other disciplines, especially the legal system, to show how corpora can be used to disambiguate language. Sara has presented on her corpora and her corpus research at top linguistics conferences in the United States. Sara was recently hired as the Corpus Linguistics Research Fellow at the J. Reuben Clark Law School. James Phillips is a PhD candidate in jurisprudence and social policy at UC Berkeley, from where he also obtained his JD. He has clerked for Judge Thomas B. Griffith on the U.S. Court of Appeals D.C. Circuit, as well as for Justice Thomas R. Lee on the Utah Supreme Court. He also holds a bachelor's degree in history and a master's degree in mass communication. So please join me in welcoming Ms. Sara White and Mr. James Phillips.
Thank you. So we're going to take turns here, so I'll go first. First, just let me say I'm grateful to South Texas College of Law for the invitation to be out here, and as well as with Sara. And impressive-looking group. I've been at other law schools, and usually you hope they're just dressed, right? But, you know, lots of suits. Looks good. So I want to first just kind of set expectations. Just really briefly say what we're not going to talk about. So our research doesn't get into historical practice. It doesn't go beyond before 1760 or after 1799. It's a very narrow look at one thing, and unfortunately for Professor Graywall and most of you here who went to law school because you didn't like numbers, there are numbers. Although it's not really too much worse than the numbers you'd see in like a poll of who's going to be elected president kind of thing. Okay, so I want to start off with a quote from someone who's very radical, a Supreme Court justice who's no longer with us, but you all know who he is. And once in oral argument, some attorney was asked a question by a justice, and the attorney said something like, well, that's just semantics. And this really got the justice a little upset. And he said the following. I'm going to give away who the justice is here when you see the name. He said, all our work is a matter of semantics, because words are the tools with which we work, the material of which laws are made. Everything depends on our understanding of them. And of course, that was that, right-wing nut, Justice Felix Frankfurter, who helped found the ACLU and was put on the Supreme Court by Franklin Delano Roosevelt. So I really want to build on this. The law is words. Words have meaning. And that meaning is what we have to figure out. So, again, we've seen the words before here. We have the text, and we're going to focus on emolument. I'm not going to get into this too much since we've already seen it a couple times. But let's talk about how we understand what the words in the Constitution mean. Now, you've heard of the term originalism. That is kind of the school of theories that deals with how we figure out what the words meant at the time that the Constitution was adopted. There's some variants. So let me just highlight these real quick. There's one that's called original intent. And I think Professor Teachout was kind of hinting at that kind of school of thought a little bit. What was the intent of the framers in adopting the language they did? Another one is called original understanding. What was the understanding of the ratifiers in state conventions when they were ratifying it, since they're the one who kind of made it law? James Madison kind of described to this view. Then we have original public meaning. I'm going to get into that a little bit more in just a second, but that's how would it have been understood in the day. And then finally, we have another one called original methods. That's where you figure out how legal documents are interpreted. at the time, and you take those interpretive methods and you apply it to the Constitution. Now, the reality is there's a lot of overlap here, and for the most of the time, these are going to point in the same direction, although not necessarily always. But all people who do this kind of scholarship tend to agree on two principles. First, that the meaning is fixed. So when the Constitution is ratified, except through the authorized process of page out, which in the way of the Constitution would be through amendment process. And it also means that linguistic drift cannot change the meaning of the Constitution. So, for example, in the Constitution we have the term domestic violence. Right? That has nothing to do with how you treat your spouse. But that's what that term has come to mean today. So linguistic drift can't change the meaning. Also, the meaning constraints, right? It's the law. So let's talk a little bit about original public meaning, because that's kind of what our research is most in line with as far as what we're doing today. And Randy Barnett, a famous law professor at Georgetown, described it as this. And there's other quotes that are similar, but the meaning, words, and phrases the Constitution's text would have had at the time they were adopted as law within the legal and linguistic community that adopted them. So that means sometimes things are legal terms of art. That means sometimes things are just kind of how the ordinary person on the street of the day would have understood it. And of course, we have to pay attention to context. So how do we do that? Well, traditionally, folks have done one of two things or both, usually. And we've seen some examples of that in some of the recent scholarship on the Foreign Emoluments Clause. So Rob Nadelson has an interesting piece that's going to be published at the University of Georgia, which actually is an interesting counter perspective to Professor Teachout's scholarship. What does Professor Nadelson do? Well, he looks at some sources from the time period, right? And looks at how they're using the term emolument. Now, the problem usually, and Professor Nadelson, I respect, and he actually has more than you often will see in scholarship. But the problem with this technique is often we're not talking about a lot of examples, right? If you're going to generalize about something, you've got to have a big enough sample to be able to say something that's meaningful. If I want to know what the opinion of Texans is on an issue, and I ask the 30 or 40 people in this room and then say, this is what Texas thinks, well, I've got a sample size problem. I also have a representative problem, right? The sample is probably skewed if I just stick with this room. You're lawyers or law students. You may have a less than representative view of the state of Texas overall. And family area documents often tend to be a little skewed as well, right? They tend to be the framers, or they tend to be certain types of documents. And so it's really hard to say something that generalized to the 2 million people in the colonies and in the early republic based off of a few sources from a certain segment of society. Although Professor Nadelson goes into more sources than most people do. The other thing that people turn to is they turn to dictionaries. And dictionaries, I love dictionaries. I honestly find reading the dictionaries interesting, but they're maybe not always the best tool for answering this question, and here's why. First off, dictionaries don't do context necessarily very well, and I think Professor Graywall hit on that a little bit earlier. They can give us definitions, and you can get some context from definitions, but the context is not their forte. They don't do phrases, right? And words, and Sara will kind of hit on this a little bit later, but words, when you start adding words together, and the phrases can take on new meanings that aren't necessarily the sum of the individual words. Dictionaries don't do frequencies. So to the extent we're trying to understand how people of the day would have understood something, if a certain definition or sense of the word occurs way more often than the other, then we might think in a context, and we might think that that's how they understand it. So for example, in the context of apple, if I say green, you are almost certainly going to think of color, right? In the context of A building, if I say green, now we're going to start getting some ambiguity, right? 50 years ago, you would have thought color. Now you're like, well, is it like kind of environmentally certified building, or is it actually just the color? If I say green in the context of movement, you're probably thinking kind of an environmental movement, although I understand there's also kind of a green movement in Iran a few years ago, right? So again, dictionaries can't tell you in a context which sense is being used the most. They can tell you what's possible, but not what's probable. Finally, dictionaries historically have tended to be normative in the sense that they tell you what the correct definition is, how it should be used. Whereas in the 1960s, Webster's Third International Dictionary, which, fun fact, is also the dictionary cited most by the US Supreme Court, did this radical thing. It broke from this past and said, you know what, we're not going to say what the meaning should be. We're instead going to say, this is just how people use this. We're going to go on usage. And this was seen as, this was controversial amongst lexicographers. I'm sure it didn't make the New York Times, but if we're trying to understand how people would understand something, maybe we should be looking at how they actually use it then instead of what the proper use is. Finally, founding era dictionaries, which have some of their own problems that modern dictionaries don't. One is they tend to be the work of one person. And because of that, we find some things. First off, if one person's putting the dictionary together, it tends to be a little idiosyncratic. Okay? Their views of language are heavily influencing definitions and what goes in. Another thing that kind of cuts and can sometimes combine and sometimes cut in a different way is they plagiarized. If you've got to put together a dictionary and you're one person, you can kind of understand why you might copy the definitions of another. One study looked at, I think it was the letter K in one founding era dictionary's dictionary, and found that at least 30% of the entries had been just copied from Samuel Johnson's dictionary 100 years earlier. So they plagiarized it. Because of that, sometimes what happens is you get a false consensus, right? You might think, well, look, all these definitions and all these different dictionaries are the same. Well, why are they the same? Are they the same because that's how people use language, or are they the same because they were copying each other? That's something that requires a little more research and something I'd eventually like to do. You also get, because they copied, copying Samuel Johnson's dictionary from 100 years earlier may miss some linguistic drift, right? Because definitions do change, and they changed back then too. In the 12th century, the word deer actually meant all four-legged animals. And now, a couple hundred years later, it kind of became the meaning that we know of it today, just represent one animal. So that's a problem, and at the same time, they also like to use things like the King James version of the Bible or Shakespeare for usage examples, for illustrating what words meant. And that's all fine and good, but we're talking late 1400s to early 1600s. That may not reflect how people were using language in the late 1700s. And finally, we have this concept of lumpers versus splitters. Lexicographers, and actually probably all of us in some sense, tend to fit into one of these two categories. So let me explain this. So when writing definitions, they tend to be either lumpers or splitters. Lumpers are definers who tend to write broad definitions that can cover several more minor variations on that meaning. Splitters are people who tend to write discrete definitions for each of those minor variations. Now, if you're writing a dictionary all by yourself, what's it going to be easier to do? It's pretty easier just to kind of put everything together, right? And not finally put these nuanced types of definitions. And so these founding era dictionaries tended to be lumpers. Now, and that actually has some relevance here because the two senses that you've heard talked about today, a broad general sense of emolument, any kind of gain or advantage, could include financial, could not, versus a narrower sense, which is some kind of financially measurable benefit tied to public employment or office, well, that narrower sense fits into that broader sense. And if I'm a lumper, I might not even note that narrower sense because it's covered by the broader sense. And so Professor McHale looked at, I don't know, 40-something, finding our dictionary switch, by the way. That's great, because a lot of times when people use dictionaries, they cherry pick. And there's no cherry picking here. I just think it's maybe not the right instrument to get to the question. But he found 92% of the dictionary definitions that from this time use the broad sense. And another 8% also add this narrower officer sense. And from that he says, well, then the ordinary meaning, the most common meaning must be this broader one, and therefore that's what the Constitution must mean. Well, I'm not so sure, because I'm not sure the dictionary, because of these problems, can actually answer that question. So what do you do? The methodology of original public meaning, how would people of the day, lawyers and ordinary folks, have understood the language of the Constitution, hasn't really had the methodology to date to answer that very well. And so what we need to do is improve the accuracy and the reproducibility of what is really an empirical question. It is an empirical question, how would people of the day, of a certain time period, have understood language. So, what do? Well, we bring in something called Corpus Linguistics. Sounds fancy. Corpus means body, of course, as lawyers and law students know. Even shows up in the Constitution, habeas corpus. But for a linguist, a corpus is a body of text. And we actually use things that are kind of like a linguistic corpus. Google, Westlaw, LexisNexis are corpora of a sort. They're kind of unstructured raw corpora, and they're not designed to necessarily get at meaning, but they are a corpus, a body of text. And when you're doing a Westlaw search or a LexisNexis search and you're trying to figure out how courts are using a word, you're kind of doing a very rudimentary form of corpus linguistics. So this isn't quite as foreign as it sounds. So what makes a linguistic corpus a little different, and what are the tools and features that you can use on it? Well, first off, they're usually designed to get at a certain speech community. The premise of corpus linguistics is we want to see how people use language when they don't know they're being studied. So we find naturally occurring uses of language, and then we start looking for patterns in that usage. There are general corpora, there are more specialized ones. I mean, I can make a corpus out of the transcripts of the Buffy the Vampire Slayer TV series, right? I wouldn't be able to say much about the rest of the world, but I could maybe say something about that TV show. They're really seeking to be representative, so if you only have a corpus of, say, the Federalist Papers, it may not be fully representative of the type of language use at the time of the founding. Some of them are continually updated. Some of them are just historical in the sense of they're bounded by a certain time. And then some are raw, which is just the words. Some are tagged for parts of speech. And some are even parsed, which gets into grammar, but that has to be done by humans. They haven't got computers to do that well enough yet, so those are pretty rare. So what are the tools of a corpus? One is called keywords and context. I'm going to show you an example of that in a second, where you have the word or phrase, and you can kind of order the words to the left or the right of it to just kind of quickly look through it and start looking for patterns. Another one is concordance lines, and this is just like hits in Westlaw, right? It's where you can look in the context of so many words before and after and get a sense for how something's being used. And I think this is the meat of, I think this is where we get the most bang for our buck here. Also, collocation is dealing with word neighbors, collocation. So this is something that lawyers know. We have a fancy Latin phrase called nocere ausis. A word is known by its associates. And corpus linguistics have known this for some time, and they try to use that. And I'll give you an example of that in a minute. The other one is frequency data. We can kind of get a sense of things when we see patterns and numbers. Okay, so here's just an example of keywords and context. This is the term involuntary servitude, from from the 13th Amendment, and you can, some of them will color it based on parts of speech, and you can, order this by, here we've got alphabetical order by words to the right, but, there's various ways you can do it, just to kind of scroll through and sometimes start to get superficial patterns that you can dive into more. And then here's an example of collocation. This is the verb happens, happened. Most of us, I think, would think that's a neutral word. If you look in the dictionary, it doesn't say anything about it necessarily being dealing with negative or positive things, because bad things can happen, good things can happen. But when you look at the top collocates of the verb to happen in its various tenses, what you see is most of the time we tend to use bad things more than good, right? Terrible, accidents, nothing, horrible, Forrest Gump, unthinkable, untoward. We do have miracles, okay, so there's a positive thing, and then we have some other things that are a little bit more neutral. But there's what this is called semantic prosody, or it's kind of like the valence, positive or negative. That's something you can see quickly from collocates that would be hard to intuit, because we just don't have enough data in our brains. Okay, so for this study, we built 3 corpora in order to get at this. Now, the data from these 3 corpora is actually going into a corpus that the Brigham Young University Law School is building called the Corpus of Founding Era American English, or COFIA. It is not quite yet available for public. Hopefully early 2018 it will launch. I think within the next couple of weeks a private beta version will be available for people just to play with. So we built 3 corpora because we kind of wanted to see some different types of documents, some different types of authors. So the first one comes from Hein Online, a great database if your law school probably has access to it. And so this is legal materials. This is cases, statutes, the Journal of the Continental Congress, legislative debates, that kind of stuff. It's about 49 million words. The next one is from the National Archives Founders Papers Online. This deals with 6 prominent founders. So for those of you who are interested in maybe how the founders use language, that kind of covers that a little bit, although it's a different type of documents. There's letters, diaries, other papers. As most of us, I think, would understand, we tend to use language a little differently depending on the medium or genre, right? If I'm sending an email to my brother, it might be a little different than if I'm giving a speech or if I'm writing in my journal, etc. And the great thing is, it's a lot of these guys. There's also letters to them from kind of just everyday folks. So you do get some of the common folks there. That's about 44 million words. And then we have the Evans Early American Imprint series, which has books, both fiction and nonfiction, and these books often have other types of writing in them, such as essays or plays. Broadsides and pamphlets from all types of authors in the founding era. So we have a variety of author types, a variety of contexts, legal or ordinary, and a variety of documents. Okay, so let's talk a little bit. We found a lot of what we would call to be subsenses of these 2 broad senses as we dove into this. So we were splitters. You have the broad one here, any advantage, gain, benefit, or profit. And there's an example of one of those. Another sense that we're going to tentatively call 2A1 is just the proceeds from some kind of financial value from any kind of gainful activity. So your job, it could be emoluments of my profession, is an example of that. More broad senses are kind of familiar with this broad. Sometimes it talks about the government receiving emoluments or a country. So if Great Britain engages in commerce with us, then they get kind of an emolument. Sometimes the government will authorize direct or indirect emoluments. They may take a private person and authorize them to collect tolls on a bridge that they can keep, kind of thing. They haven't necessarily put that person in employ, but they've given them authority. We have private organizations that will grant emoluments in a similar way, like a business will say that the president has certain emoluments for his office. It's not a government office, but it's kind of a private equivalent. And we also have these other terms talking about personally benefiting from office. Maybe you're skimming funds, right, as the state treasurer, or just you're earning money on the side. I have a business on the side. I have this government employment, but I also, sell cattle, or I bootleg, or whatever. So those are some of the broader senses that are general and aren't tied to officer. Now, the narrow office or public employee or agent, sense, we found kind of two subsenses, and these are similar to also what Professor Nadelstein found. One is it just kind of covers anything, right? Anything that's legally authorized for your employment, which would include salary, but other types of things. And then there's an even narrower one. It doesn't include the non-financial stuff. And there's an even narrower one which isn't talking about salary, but kind of some other types of perks. And I think Professor Graywall hit on some of those earlier. Okay, so these are the various senses, subsenses that we found looking in this data. Stuff that isn't covered in founding era dictionaries. In part because they were lumpers, in part because they were plagiarizing each other, in part because they may have just been relying on a few old sources for their data. So let's think about for a second, how could President Trump violate the foreign emolument clause? Well, obviously if he was made some kind of officer or agent or public employee by a foreign government and provided some form of compensation, he would be violating the narrow officer related sense. If we're going into the broader senses, if he was, given a business license, then that would violate sense what we're calling 2A3, because he's given an indirect financial benefit. If he's making money on the side with business transactions, he'd violate sense 2A1, which is kind of, I think, the Trump Hotel argument. And then finally, if there's just some kind of other tangible benefit that he's getting from a foreign government, then that would violate the broad sense one. Okay, so let's talk a little bit about how we generated our data. So we sampled based off of document, because, and people who do surveys do this as well. So for example, when people are calling and doing some kind of public opinion poll, they often will survey based on household rather than based on person, because they assume that opinions in a household are highly correlated. And so they won't, if their random generation of who they survey picks two people in the same household, they won't do both. So we tried to look at documents. We did 200. So far we have a random sample of 200 from each of the three corpora. So we've got 600 instances from founding era. We're actually going to keep building on that, but that's as far as we could get so far. So we've got confidence intervals of about 5 to 6% at the 95 confidence level. That means we're 95% confident that the numbers we're about to show you are within about 5 or 6% for the whole, for the whole corpus, right? So for example, in the Hein corpus, I think there were over 1,100 hits, 1,100 instances of the term emolument or emoluments. We sampled 200 of those, and so what we're saying is we think if you had looked at all 1,100, you've got about 5%, 5 to 6%, error rates on the numbers we're actually going to show you. We independently coded them, Sara and I, and we had about an 89% agreement rate, and the ones we disagreed on, we sat together and looked at it and discussed it and came to a consensus on those. Okay, so first off, just straight up frequency data, all right? This is how often does the term emolument or emoluments appear per million words in each of these three corpora. And it's kind of interesting that there is some variation, right? Evans is more ordinary documents and more ordinary folks. And we see it occurring about 11 times per million. Founders and Hein, so Hein is legal stuff. And Founders is a kind of mix of its more ordinary documents and some ordinary folks and some elite folks, but these elite folks tend to be in government, and a lot of what their letters were writing were also about government business. Interesting that it doesn't appear as often in this more ordinary material. Okay, so let's look at context, something that Professor Graywell talked about earlier. Another thing we coded for was the person who was being referenced in relation to emoluments an officer, and was the source of the emoluments the government. So in Hein, you can see that around 70% of the time, when we're talking about emoluments in this legal context, we're talking about emoluments with an officer, and we're talking about them from the government. Similar numbers when we're talking in the founder's corpus. And when we go to Evans, which is more ordinary materials and more ordinary folks, we see around 40% of the time we're talking about it. So we do see that there seems to be a bit of a difference based on the materials as far as the context of emolument. Okay, so now let's get into some nitty-gritty. So in the Hein corpus, we find that the broad sense is used about a quarter of the time, and the narrower officer-related sense is used about 2/3 of the time, with some of the times it was ambiguous, we couldn't tell, so about 5% of the time. Similar numbers when we're dealing with the founder's corpus. Again, 2/3 of the time, when they're using the term emolument, they are using it in the context of the narrow sense relating to office or public servant, public employee, agent, commissioner, etc. And finally, the Evans is a little bit of a flip. You get about 55% of the time, they're actually talking about the broad sense, and then about a third of the time, they're talking about the narrow sense. So how could this be so different than the dictionaries from the founding era, where it's 100% of the time they have the definition for the broad, and then 8% of that 100% also has the narrow? Well, again, I think for some of the reasons that we talked about earlier, that dictionaries may not always be great at capturing usage. They more capture what's possible. And even then, in the founding era, maybe not so much. Okay, so let's just say the Foreign Emoluments Clause is talking about an emolument that isn't tied to this person's U.S. office, but it's coming from a foreign source. The question is it coming from a foreign source because that person is some kind of officer with the foreign government or for some other reason? And so, looking at all of the corpora, in the sense of where we coded it, the source of the emolument is from government, we see that even in Evans, which is more ordinary materials, when we're talking about an emolument that's coming from government, almost all the time we're talking about it in the officer sense, not in a kind of broad sense of the government is somehow bestowing something on someone. Okay, so I'm going to turn over to Sara, and she's going to talk about some of the other things that we found.
Okay, thank you, James, and thank you to all of you again for the opportunity to come here. So as James explained, we did a few different types of linguistic analysis, and what we're getting at is looking at the semantic meaning. So to do that, he said, we have to look at the semantic and syntactic context of the words, because context is what it all comes down to. So one of the first things in the linguistic analysis that we do to help kind of drive our study is looking at the collocates, like James explained. So here are the collocates, the most common collocates of emoluments in the Evans and the Founders corpora. So these numbers here are the frequency and then a statistical relevance, telling you how statistically relevant this word is. And so if we look at both of these, we start to see these results that kind of drive and support what James has already explained. That these when fees and emoluments are used, when emoluments is used, it is usually leaning towards talking about a person in office and the compensation that they get for that. So then, using this to kind of drive our research, we did something called a cluster analysis. So a cluster analysis is looking at the most common groupings of words in a corpus. So we want it to look for groupings of words that have the word emolument in it. So we did a 3 cluster and a 4 cluster. Sometimes you'll also see this in other studies called n-grams, like a 3-gram or 4-gram. And so here, this is another way that we can start to see trends emerging. And the key to this type of analysis is that the trends in the data are driven by the corpora. They're not driven by what either James or I thought we were looking for or wanted to find. So we use this type of quantitative analysis to help drive our later qualitative analysis. So here again, we start to see these common clustered themes. So here in Founders and Heim, again, we see them using most commonly the honors and emoluments or pays and emoluments, again referring to some type of compensation. And these again were used in the context of talking of office. So then if we look at the 4-grams or 4 clusters, which just mean that there's 4 words now instead of 3 that we want to look at, we see again that we have these common themes like pay and emoluments, present emoluments, emoluments of office, emoluments of my office, emoluments of that office. And then in Evans, we see similar trends, but they're a little bit less tied specifically to office. So the Evans ones seem again to be going more towards the broad view. So we see a monument from the United States if it was not cut off, or a monument of the community, and this isn't necessarily tied to financial compensation for office. So we took these clusters and we used them to guide our next step of analysis, which was looking at specific n-grams. So for this type of n-gram analysis, we took the n-gram engine and we looked at how often they were occurring in each corpus. So we looked at these specific ones, honors and emoluments, and then the reverse emoluments and honors. And so the X is just where it was left blank, where we didn't want to put a specific word and we just wanted to see what came up. And then the S for whether it was plural or singular. And so here we started to find that, once again, the most common context in which emoluments was used was when dealing with some type of compensation for office. So again, we see honors and emoluments, ranks and emoluments, pecuniary emoluments, emoluments of officers, emoluments of advantages. And so again, all of this data is in support of what James has already explained, that the majority of uses are the more narrow sense of the word, and they're in the context of a government official or an office. And so another thing that emerged here that is important that we are hoping to get into more is looking at these specific, what are called like binomials, so these groupings or phrases. So if you look at these like honors and emoluments, it started to take on almost a term of art meaning. So one of the ways that we look to check for this is by trying to flip that word pairing around and see if it's just as common. So here we have honors and emoluments, and then underneath it tabbed over we have emoluments and honors. And so honors and emoluments in all 3 corpora appeared 85 times. And then emoluments and honors that reversed only appeared 10 times. So this is showing a trend of rigidity or passiveness. So this phrase, it supports that it's taking on a term of art, and this term of art is being used in the government or official realm. Speaking of financial compensation. So all of these together are just the different types of linguistic analysis that we use to try and determine what this word meant when it was used in the different different contexts. So what did it mean when it was used in the context of the president of a corporation talking to his stockholders? And what did it mean when the president of the United States was talking to his officers? And so we see again, yeah, that these are in support. And so one of the other things I wanted to just point out is that this type of linguistic analysis goes back and forth between the qualitative and quantitative. So some of what James got into was the quantitative, looking at the percentages and all of that, but those percentages came from a qualitative analysis that each of us did, looking in depth at each line of data, so that we're not relying too much on a computer analysis or too much on one researcher or two researchers' analysis. So now I will turn the time back over to James.
This is the last slide. Returning to Justice Frankfurter, he said this, that a problem in legal interpretation can seriously bother courts only when there is a contest between probabilities of meaning. Probabilities and numbers, they're data. And so, based on what we've seen so far in these three corpora, it seems unlikely that the foreign emoluments clause would have been understood in the late 18th century as referring to the broad sense of emoluments. It seems much more likely that, given the context, it referred to something that flowed from office, public employment, being an agent hired by the government, etc. So, in that sense, based on what we currently know, the president doesn't appear to be violating the foreign emoluments clause. Again, that's a statement that is a probabilistic one, right? You can only go based on the data. The data can't say 100% or 0%, or at least this data doesn't. Now, if other things are turned up, who knows? If tomorrow Mueller comes out and says that actually we have a document here that President Trump signed and he's actually, secret agent for Russia or something, then maybe that's something different, right? But based on the data, all we can say is that most likely that's how people would have understood the foreign emoluments clause in the late 1800s. Now, whether that matters for you and your version of constitutional interpretation is a whole totally different question. But that's where we're at right now, and we're going to continue to dig into the data. It's unlikely to change significantly based on the probabilities you saw, but who knows? We'll know more in the coming weeks as we do some more analysis. Thank you. We've got a couple minutes for questions.
Yeah,
5 minutes.
I was wondering, I don't think that you mentioned this, when you were searching Hein Online and the two other sources, did you record the type of document that the words appeared in? Like, this was from a diary, that was part of your analysis?
Yeah, so that's called genre or register, the type of document it is. And that's something that we're working with the BYU to record that kind of metadata. So eventually what we'll have is source of document, date, actually eventually, hopefully, location. But is this from South Carolina or is this from Massachusetts? Maybe they use words a little differently. Eventually, you're going to have author-specific information. You could even get into stuff like what type of profession was this person, what's their gender, socioeconomic class. We have in ANCONC is the corpus software we use to do this. It's where you can make your own corpus. And it records the document. But we have not yet gone back in and said, this is a letter. This is a case. We can do that once we've finished our sample. We're probably going to go to about 250 from each, so we got a little bit to do. Then we can go back and say, okay, and look for patterns in that as well.
Yeah, cool. Yeah, I just thought that was
that's pretty standard. Because we designed our own corpus, it's something we have to do a little bit on the back end rather than the front.
Yeah, and I would say the closest that we have to that is the 3 different corpora that are still 3 different registers of English. So we have the registers again at the specific genres of, like, yeah, what type of document.
Thank you, James and Sara. This is fascinating. You don't know how cutting edge this stuff is. You're the first people to have seen this. I haven't even seen it, so I'm very blown away. The question is this: how are judges supposed to apply corpus linguistics? Let me caveat my question by saying that the former boss of Mr. Phillips, Justice Tom Lee of the Utah Supreme Court, is, I think, the first judge ever to use corpus linguistics in opinion, or close to it, and none of his colleagues joined his opinion. Am I right about that? So, I think you persuaded me, probably most of the people in this room, but how do you translate that to the judiciary? How do you package statistics to a group of people who have no training in this, and likely went to law school because they hated math, they didn't want to go to med school, or they didn't want to become an engineer? I mean, so, how do you translate corpus linguistics to Justice Frankfurt and an opinion? Like, what's the next game step?
Yeah, well, I think there's two things, right? One is people start putting it in briefs, and courts can rely on briefs. They, obviously they do that. They rely on historians' brief for history, but judges will also do their own history, right? At least some. So I think mostly what you notice in the stats here, where they were what's called descriptive statistics. It's what's the percentage. It's not inferential statistics. That's stuff like regression, right? That's stuff that you generally need a graduate degree to properly do. Basically what we're doing is something that's similar to a Westlaw search, at least the concordance line stuff, the stuff where you saw the bars. The stuff that Sara was presenting on, at least some of it, it's stuff the corpus does itself, but there were a few statistics that may require a little bit of additional interpretation. But imagine going into Westlaw and doing a search and getting 100 results, reading through the 100 results and saying, are they X or Y, and putting them into those bins and then counting them up. I mean, clerks can do that. A judge can do it, but most judges don't even use Westlaw. So it's not really that foreign. It seems a little foreign, but it's really quite similar to something that we kind of already do. We just don't do it in a very more rigorous, transparent way. Now what people do is they look through a lot of search results. They get a kind of an intuitive sense on what the patterns are. They make their decision, and then they'll cite a few examples to support their decision. And this is just taking that to a little bit more rigorous level, but it's a difference in degree, not time. So it's just going to take a little time, though, because when, a few of you may remember this, but when Westlaw and LexisNexis went computerized, went from paper to computer, there were people who thought this is going to ruin things. This is bad. They resisted this technology change. Now, most people today would say, I think we've done just fine. So there's always resistance with new things. We'll see where this goes.
Another good question.
I would just add something with this.
Fine.
So then also with that, James came to that. So judges are doing this already with dictionaries and things like Westlaw. And so Corpus Linguistics is giving them the same methodology, just with better data to search through. Another case, I think it's the United States versus Costello, Judge Posner, and to determine the word of the meaning of the word harbor, like to harbor a fugitive or harbor a criminal, he did a Google search, and he looked at just did the exact same thing that we did, but with Google results. The only problem, while this is like really cool, the only problem with that is like Google doesn't tell you how their search results appear. So if you're going to the top 100 results of Google, you don't know if that's because they're the most common or what, and then also it's just web pages that show that word, and it's not the number of times the word occurs altogether, if that makes sense. So you could have one web page, or sorry, like 10 web pages that have the exact same text on them, and then you're messing up your counts. So yeah, it's something that's already happening. We're just trying to help people and judges, I guess, have more sound data when they're doing that type of research.
So don't use Google.
Yeah, don't use Google. But there are so many tools out there that you guys can use that are all free to do this type of research.
And don't cite dictionary definitions orders for what is the most prevalent or primary definition. Justice Breyer did that in an opinion. If you look in the front matter of dictionaries, usually they order the senses of a word based on when they historically appeared. So if you go to the Oxford English Dictionary and look at emoluments, the officer sense of the word appears first because it appeared on the scene a few hundred years earlier than the general sense. So, and a few dictionaries don't do the historical ordering, but just don't fall into that trap. This is the first definition, it must be the primary one. There's the answer to my question, because that's just not true. Thank you.
Now what I'd like is Andy to come back up. And, no, you're not done. I'll moderate, I suppose. And Andy, you want to take a seat? Unfortunately, Zephyr could not join us for this second thing, but you got mics there? You got water? Yeah, Andy, please lead off by all means. Go ahead. And we have till about 12:55. So we got some time to.
11:55 or
11:55.
So, I guess I like the results because it confirms what I think, but I'm still worried about this method. I was hoping maybe you could clarify or analyze. And let's forget about the word emoluments. I think maybe it's a little bit easier to think of a more modern name. Let's think about the word profitable. Now, I could use the word profitable in a very general sense. I find it profitable to read the poetry of W.B. Yeats. Okay? I'm going to understand that one way. That's going to be like the general definition of emolument. So I'm just generally enjoying some type of gain or advantage. If I said that my business was profitable, you probably would understand that as saying the excess of revenues over costs. Now, in my first example, where I said I find reading the poetry of Yeats profitable, it's linguistically possible that I made money off of it. I mean, it's linguistically possible. It's not ungrammatical. And my concern is that if we're trying to determine the meaning of my first statement, I find reading Yeats profitable, and I guess technically it is ambiguous. It is linguistically possible. I'm referring to making money off the poetry. Is that ambiguity that I've identified enough to say, well, 94% of the time when people say profits, they mean profitable, they mean revenues over costs, therefore I must be referring to making money by reading the poetry of Yeats. And how does that kind of fit into your analysis here? And then I suppose this fits into my second question. You referred to that the officer definition is a subset of the first definition. And again, I suppose when I say it's profitable for me to read Yeats, that is a broad definition. I mean, technically, excess of revenues over cost is a class of general gain, but I don't really view business profits as a subset of the definition of what I find it profitable to read. It's almost like I don't view the second definition as a subset of the first, which is relevant for our emoluments. Can you flip back to that slide?
Which one?
The where they list the clause early on.
Yeah, it's like third or fourth slide.
Yeah, and so
you know it by heart yet, Andy?
I do.
For shame.
Well, I want to point for other people to read. I know that of any kind, whatever. It's yet to have to look at it. My concern is that if the second phrase is a subset of the first, this clause says not just emolument, but of any kind, whatever. And so if I'm going to apply your analysis where I'm not focusing on the legal context, it seems like showing that emolument most of the time means compensation for services doesn't answer the question because we have this phrase any kind, whatever. So your thoughts on how you deal with my profitable hypo, and how your analysis takes into account the legal context of saying of any kind of whatever.
So this is an interesting question, right? When you have broad senses that potentially could cover narrower senses. So think of the First Amendment, right? It talks about free speech. we think of that term as rather broad. We certainly wouldn't think of it as limiting when I go give a speech in public. And yet, there are times when we use the term speech, and we mean a speech. We don't mean what the term speech means in the First Amendment. We don't mean any kind of communication. If I was hired to go give us, well, if I was hired, like, say, our ex-presidents tend to be hired to go give speeches to corporations, and I showed up and just had, wrapped myself in a flag or did some kind of expressive dancing, I don't think they got what they had bargained for, right? So I think at the end what we have to do is think about context. And that's why I don't think it's enough to just say, if you look, most of the time it's being used in this sense. I think that's why we have that additional analysis of when we're talking about an emolument from government, what sense do we see? When we're talking about an emolument tied to an officer, what sense do we see? And again, it's probabilistic. You're absolutely right that it's possible to read it the other way. Generally with original public meaning and also textualism when it's doing ordinary meaning, which is a very similar concept, the notion that courts seem and scholars seem to be invoking is what's the most common or frequent sense. And so if you have something that in a technical sense could be a subsense, but that is the most frequent sense in that context, then my thought would be then that's what you go with. You don't go with the broader one, just like if I'm going to go give a speech to AT&T, it has to be, I stand before people and I talk. It can't be all the other forms that are covered under free speech, because that's just a different context, even though it's broader and technically covers the narrow one. But there's some interesting stuff that needs to be done about ambiguity.
Now, James, let's look at the other emolument clause. This is not only a concept of the foreign emoluments clause, but the emolument clauses. There actually are 3 provisions in the Constitution that refer to emoluments. So we've already looked at the foreign emoluments clause, right? We read this already, which says no title nor ability shall be granted to the United States, and no person holding any office or profit or trust under them, that is under the United States, shall, without the consent of Congress, except of any present, emolument, office, or title, and then he said, of any kind whatever, from any king, prince, or foreign state. We also have what I call the presidential emoluments clause, we call the domestic emoluments clause, which says the president shall, at stated time, receive for his services a compensation, which shall neither be increased nor diminished during the period for which he shall be elected, and he shall not receive within that period any other emolument from the United States, or any of them. Now, Sara and James, how do you think emolument maybe differs in this context rather than the foreign emoluments clause, where it's of any kind, whatever, where that seems perhaps broader? This is emoluments from the United States.
So, I think what Professor Blackman's hitting at is something that Killamar calls intertextualism, which is where you interpret a document, if the same word or phrase appears multiple times in a document, especially a legal document, the presumption is you give it consistent meaning. So if there's competing senses and it's 2 senses use the same in a couple instances, and you apply it different. Now it's a presumption, it's rebuttable. And the foreign emoluments clause seems a little different than the other 2 because it's not explicit as far as tying the emolument to office. But I think, at the end of the day, the data that we found supports the fact that we're using the same sense in all 3 emoluments clauses in the Constitution. As far as the any kind whatever, again, I think you have to think about context, right? So there are different types of emoluments in the officer context. Emoluments can refer to salary. It can not refer to salary. It can refer to various perks of office. So emoluments within and of itself has some variety in the office context. And so my view from the data is that the best reading, at least that we've seen so far, is that any kind whatsoever means that any type of emolument in the officer context is barred. It doesn't mean that if there are other types of emoluments that are not in this context, that's being covered as well. But again, I'd rather have this kind of debate than you cherry pick 3 things, and he cherry picks 3 things, and she cherry picks 3 things, and we, kind of have this circular fight. I'd rather, let's get the data out there, and then maybe if we have some disagreements about, broad versus does the broad cover the narrow, what role does context play, I think that's a much more transparent and productive debate than a kind of law office linguistics.
Ooh, fighting words. Law office linguistics, Andy.
Yeah, so I think I agree with all of that, especially there are different types of emoluments associated with the position, pensions, right to servants, and so on. I'm curious, just from your perspective as linguists, to what extent this phrase, any kind, whatever, adds anything. If you tell me any emolument, think of the phrase as broad. If you tell me any kind of emolument, I'm not sure that it could be any broader. And then if it says any kind, whatever, what is whatever adding other than emphasis?
Whatever.
Whatever, yeah, so that's what I'm for. But anyway, do you think that any kind, whatever, adds anything besides the phrase any?
So there's a question of whether it's a term of art.
Yeah, I would lean towards it, being a term of art, or like I talked about before, something like a binomial or a hendiasis, which just means that it's a phrase that has its own meaning as if it were one word. And so the any or any kind whatever doesn't add anything extra. It's just a phrase.
May I suggest a
But
section
that's
for your
an
paper?
empirical question.
Yeah,
That
so
that's-
James and Sara, may I suggest for your
Yeah.
paper for the South Texas Law Review that maybe you address what Andy is asking. I think that's a worthwhile discussion, because I had the exact same thought as Andy when I was listening to your paper, because it's between the presidential emoluments clause and the foreign emoluments clause, this language, emoluments of the United States versus emoluments of any kind. Intertextuals, but there are differences, so you can rebut the presumption, but I think that would be a worthwhile contribution to your paper.
I think I'd come out the same way as you did, that there's no difference, but there's a difference. If you look at the Articles of Confederation, they use the phrase of any kind. Whoever was drafting the Constitution decided to put whatever at the end. Historically, I think, again, this moves beyond the corpus linguistics, I think it's because nobody complied with this. Thomas Jefferson got gifts and then told his assistant.
Oh, you're stealing my thoughts, Andy.
Well, I won't say too much about it.
Don't steal my thunder.
He said that. He said, just sell this off and put the money in a secret bank account. And so there's this culture of non-compliance with the emoluments clause under the Articles of Confederation. And so, I think if you look at the legal context, that's why we speak the word whatever. And I'd be concerned if somebody argued, as I suppose in true will, that any kind of whatever.
They will argue that.
So, I think I end up in the exact same place as you guys. And I think, in a sense, I use corpus linguistics, not in the technical sense, but in my paper, I'll have a string cite of 30 cases saying that, there's 30 times the Supreme Court uses the word emoluments in connection with an office, and it surely means compensation. That's only permissible. And I suppose that's kind of what you're doing in the sense when you do the 3-word things. I think that for this movement to catch on, you have to take into account a lot of the law.
And now let me add one more point. The word present is in there. And we heard Professor Kijek earlier today saying that present is even broader than a bride. Right? So if it's a present of any kind, that's pretty broad. So actually, Jim, Professor Phillips, I'm sorry, I think your research fits the best with the presidential emoluments clause. And because all this extraneous language is even less useful for the foreign emoluments clause, which is where Seth and I come into play. As we argue, the president's not bound by the foreign emoluments clause. So this is the 1-2 punch, my friends, right? If the president's not bound by the foreign emoluments clause, this counts dismissed. If the word emolument in the presidential emolument clause is limited to salary, as they argue, count 2 is dismissed. And that's the ballgame. I'm giving a preview next couple of years.
I will say 2 quick thoughts. One is the fun thing about doing this kind of stuff is we didn't know how it would turn out.
Yeah. And they didn't, and this is true. They did not go into this with a predetermined answer. I can vouch for this.
He asked us to present, and we're like, okay, we'll do the analysis and see what we find. Honestly, how cool it would have been to find that, it'd be like Bernstein and Woodward, right? If that the president was violating the Mon Clause. But I just want to leave with this thought, and I'm terrible at French. Is it Molière, is that how you say, the famous French playwright? So he has some play where this guy, at the very end of it, comes to the realization that all my life I've been speaking prose, and I didn't know it. I think that as corpus linguistics gets a little bit more attention and understanding, I think most lawyers and judges are going to realize all my life I was doing corpus linguistics, I just didn't know.
Well, what a good place to finish. Thank you all so much. We're going to take a 5-minute break, and then I'll introduce Justice Brown to give our lunchtime keynote address. Thank you so much.
Thank you, that's excellent. That's so cool.
Yeah, 5 minutes.
I'll just leave.
Yeah, thank you.
Because I think she's going to switch.
Who the fuck keeps calling me?
Is there?